I'm not sure if you'd like us to check in. Do you want a case number?
You're all set, Mr. Monson.
Are you asking me, sir?
Just go on mute, everybody, place your phones on mute at this time. All right, this is case number 07 144097. This is Modern Financial Services Corporation versus Dietrich Brown. The matter is before the court on the following objections to a writ of garnishment. Modern Financial, your appearance at this time, please.
Good morning, Your Honor. J. Latif Baig, BAIG, P36820, appearing on behalf of plaintiff and the attorney of record.
All right, thank you, counsel. Good morning to you, Mr. Dietrich Brown. If you're here, say something, sir.
Yes, sir.
Oh, thank you, Ms. Brown. All right, good morning to you. I do see your objections to the writ of garnishment regarding a bank account with Bank of America. This is related to a judgment that was entered back in 2007. That judgment was renewed subsequent to that time, and the judgment is in the amount of approximately $5,000. You put on your objection that your bank account, paid representative account, someone else's funds are in that account. So I believe I may have heard as well. Let me ask you, when you say someone else's funds are there, are any of your funds in that account?
No.
Okay, so whose funds are they?
It's a special needs daughter's fund.
I'm sorry, it's a who?
It's my special need daughter. She's 22 years old. It's her funds that goes into this account every month.
All right, so she receives.
It's her account.
Let me stop you. I heard you there. She receives funds, some type of assistance or something. Is that correct, ma'am?
Yes.
All right. Thank you. Are those the only funds that go into that account, ma'am?
Yes.
All right, just one moment. So you're her payee, is that correct?
Yes.
All right, Ms. Ray.
Your Honor, I'm not seeing any evidence of the bank account. I mean, typically, when a financial institution gets a the garnishment request and required to do the garnishment disclosure, they've got to follow, as you know, numerous federal laws and regulations to assure that the funds, in fact, are garnishable. And I'm sure they've done their due diligence. They've taken a look at the account and its history, and permitted the garnishment. I don't know how her account is set up. I mean, if it's in her name only, she has control over those funds. I don't know if there's been any commingling. She's saying that that it's only used for her daughter. I don't know that.
Yeah, the respondent is indicating that the account is open for the sole purpose of administering the affairs of a special needs person who receives some type of government benefit funds. Is that correct, ma'am? The funds that pass through that account are government benefit funds?
Yes.
All right, and how long has that account been open, ma'am?
Since she's been disabled since 2000.
Since 2000. All right, and how much money is presently in the account?
$19.
All right, ma'am. I'll make the finding at this time. It seems to me that there's competent evidence that the account is an account regarding the protected interests of a person who is a protected person. And let me indicate to you, Ms. Brown, you solemnly swear or affirm that the statements that you have made to me regarding this account are true, so help you God.
Yes. Your Honor, I even have paperwork here saying that I am the paid rep on her account. That's not my account.
Yeah, I kind of figured as much based upon the way that you communicated this to me. And that's why the court's going to find that the objection is a valid objection, and that any funds that are withheld will be released to the defendant in this matter. So that would stop effectively stop the garnishment in this regard, because the court finds that the funds are indeed protected funds. All right, you'll get an order from the court in that regard in the next few days. Thank you. Good day to you. Thank you, counsel.
Thank you, Judge.
Thank you, Your Honor.
All right, good day. All right, the court now calls case number 22-184-955. This is credit acceptance versus Adolfo Miller. The matter is before the court on the adjourned date of hearing regarding the status conference court. They had set this matter over for review on today's date. Your appearance for credit acceptance, please. For credit acceptance, please. All right, do I have Adolfo Miller, last name Miller, on this Zoom at this time? Please say something if you're here. I believe that the parties, just one moment, had established payment arrangements regarding this matter and needed a review date to get that all set up. I don't have any further paperwork, but I will make a decision on what happens to that case momentarily with those notations in mind. The court now calls case number 22-188-615. This is Midland Credit Management versus Cosette Ellington. The matter is before the court, set on for a review date. I believe I heard this matter on November 1, and it said over defendant was being evaluated for hardship considerations regarding this matter. Your appearance for Midland Credit Acceptance in this regard.
Morning, morning, Your Honor. William Hill, P28608, appearing on behalf of Midland Credit.
Thank you, Mr. Hill, and good morning to you, sir. I'm looking now for Cosette Ellington. If you're on the Zoom, Ms. Ellington, or Ellington.
I'm on Zoom.
All right, good morning to you.
Good morning, sir.
All right, thank you, Mr. Hill. Update me at this time, sir.
Your Honor, I received some communication from Midland today to ask for an adjournment to review consumer's claim of hardship. I've read her answer on this case. It appears that she may qualify for hardship consideration. Midland says that they have sent out a communication to Ms. Ellington for verification of that. It appears that she may be on Social Security and otherwise uncollectible. If it's possible, could I speak with Ms. Ellington in a breakout room to verify some information?
Yeah, that definitely makes sense. Ms. Ellington, I'm going to send you a notification now to go into a breakout room. It looks like you are there's some indications that you may very well qualify under the hardship exception. And so the attorney in regard to Midland wishes to speak with you. So I'm putting you in a breakout room. Go ahead and click in, ma'am, at this time, and I'll wait on the other side. The court now calls case number 22-192534. This is Prism Lab LLC versus City of Detroit. The matter appears to be set on today for a general hearing. Your appearance for Prism Lab, please, at this time.
Yes, good morning, Your Honor. Clifford Neubauer, P70910, on behalf of Prism Lab.
Thank you, Mr. Neubauer, and good morning to you. For the City of Detroit, counsel, your appearance, sir.
Good morning, Your Honor. Alfred Ashew, PA2536, on behalf of defendant.
All right, thank you, Mr. Ashew, and good morning to you as well, sir. All right, gentlemen, if you would go ahead and update on the status of things at this point, please.
Yes, Your Honor. Plaintiff's counsel and I had a chance to talk this morning, and we have resolved the case. The amount does not require city council approval, so we should be able to process that pretty promptly.
All right, that correct, Mr. Neubauer?
That is correct, Your Honor.
All right, very well. I will note that the parties have resolved the matter. I'm going to go ahead and I have an order that I'll go ahead and issue which will be a judicial dismissal that becomes a dismissal with prejudice upon the completion of the conditions of settlement in this matter. So I'll issue that order in the next day or so, and then you go forward with your process, and that should resolve this matter. All right, good
Great,
day.
thank you. Your Honor. Have a good day.
All right, good day. All right, the court now calls case number 22196060. This is LVMB funding versus Charles Barton. The matter is before the court set on for a status and scheduling conference on today's date. The court acknowledges receipt of the answers in this matter, and the matter is properly joined before the court. Your appearance at this time for LVMB funding, please.
Good morning, Your Honor. J. Latif Beg, BAIG, P36820, appearing on behalf of plaintiff and its attorney of record, Richard Rusin.
Thank you, Mr. Ray, again, and good morning to you again, sir. Do I have Charles Barton on this matter at this time?
Yes, sir.
All right, and good morning to you, Mr. Barton. I see that this is a claim that is about some in excess of $1,200. Have the parties talked about whether or not this could get resolved?
We haven't, but if we could do this, Your Honor, if we could do a standard scheduling order and then just put us in a breakout room afterwards, and maybe we can resolve it. And if so, then the scheduling order will afford time to exchange paperwork, if that makes sense.
Yeah, well, that does make sense. It seemed to make better sense to me to go ahead and talk about it in advance to see if you could resolve it. But it seems to me that you believe that there might be some exchange of paperwork that would be necessary before you could talk meaningfully about resolution. Is that about the
Correct.
All right. So, Mr. Barton, the court tries to at least initially see if the parties how close they are and whether or not they can get it resolved. Mr. Bates seems to think that you guys would need to talk and maybe exchange some information before there could be meaningful discussions regarding resolving this matter. Anything you wanted to say at this time, sir?
No, sir. I'm totally agreeing with the attorney. We can go to a breakout room and get this settled. I'm totally fine with that.
All right, very well. So here's what I'm going to do. I'm going to go ahead and I'm going to set this matter up for January the 25th. That'll be the next action date of this matter. 1/25/23, and that's going to be at 9:30 a.m. What I'm going to do now is I will issue a scheduling order. That scheduling order will allow for the parties to exchange information between now and that date by way of discovery. And it will also allow for the parties to file any motions that they might wish to file and have them heard on the 25th, as long as they give the other side 10 days notice. So that's all going to be in writing. Mr. Barton, you'll get a copy of that in the mail from me. We'll have the next court date, which is January 25th, 2023 at 9:30. And it will also have the right of the parties to exchange information. So that's the next thing you'll get from me, and you already have your new court date. I'm going to send the two of you to a breakout room now and give you the opportunity to talk about this matter. If in fact you're able to get it resolved today, then just come back in the courtroom and I'll find some time to go ahead and talk with you and see if we can get this wrapped up. If not, your next action date, you'll get that in the mail, but you already know it's the 25th of January, 2022, right?
Thank you.
Thank you.
Just one moment, everyone. And welcome back, counsel, regarding Midland versus Cosette Ellington. Do I have Ms. Ellington? Yes, that. All right, Council, Mr. Hill, you may at this time, sir, regarding the suffix 8615.
Yes, sir, Your Honor. I've had occasion to speak with Ms. Ellington in this case. We were here earlier and there was a brief adjournment that was granted so we could investigate a hardship situation. A hardship letter, it looks like, was sent out to her former address. Ms. Cosette Ellington has now confirmed her current address. We've discussed the situation. She appears to be on Social Security disability. As such, as soon as we receive verification of that as her sole source of income, Midland will most assuredly move to dismiss the case. So if the court would consider granting us another 30-day adjournment so we can get it to her directly. She has provided her phone number and an email address and a new updated address. And I'm going to write up this report to indicate that.
All right. Ms. Ellington, you understand what's going on here, ma'am?
Yes, sir.
All right. So I'm going to go ahead and set it over for 1/5/23 at 9:45 a.m. That's a control date. If the parties have not gotten it worked out, then you come into the Zoom on that date. That's 1/5/23, and I'll take another look at where things are at that time.
What time would that be at, Your Honor?
9:45 a.m.
Thank you.
1/5/23 at 9:45. You will get another written notice in the mail at that date, but you might want to note it now. 1/5/23 at 9:45 a.m.
Thank you.
All right. Good day to both sides.
Thank you.
The court now calls case number 22-243-117. This is Brenda Fordham versus Chet's Pets LLC. The matter is before the court, having been removed from the small claims division of this court. And do I have Brenda Fordham on the Zoom?
I am here, Your Honor.
Good morning to you, Ms. Fordham. Do I have counsel
Morning.
for Chet's Pets LLC?
I have no counsel. I am representing myself.
Excuse me, Ms. Fordham, I'm not talking to you now. I think I already got you on, right? All right, I'm looking
okay, I'm
for
sorry.
whoever's here for Chet's Pets LLC. Chet's Pets LLC. If you're here, please say something at this time. All right, just one moment, ma'am. All right, it seems to me that the defendant under the court rules had this matter removed to the general civil division. As is sometimes the case, it seems to be that there has been a lapse in the notice regarding this matter. And so what I'm going to do is I'm going to set another date for the parties to come back in front of me on this matter. If defendants do not show up at the subsequent date, the court will entertain a motion for entry of default judgment. I know that because this matter was taken off of the track for small claims and placed on the general civil track, that oftentimes there is a failure of proper notice. That doesn't have anything to do with you, Ms. Ford. Sometimes that's a little bit of a glitch as it relates to the court. So what I'm going to do is I'm going to go ahead and set this up for the 20th of December, 1/20/22. We're going to send that notice out. That's going to be at 9:30 a.m. Going to resend the notice, and all parties will have to be here on that date. If defendants are not here, then on that date you want to ask for the court to grant your judgment by default. Right. I wish you well. You get the notice in the mail. Again, that date is 1/20/22, and that's going to be at 9:30 a.m. Good day to you, man.
Okay, one more, sir. It's a lot of noise. I didn't hear everything. I know you said it's December 20th at 9:30, but you said if the defendant doesn't show, I didn't hear anything after that because it's a lot of noise. Could you repeat what I would do if the defendant doesn't?
Say it again. Well, if the defendant doesn't show up at that time, you likely want to ask the court for entry of a judgment by default. You understand?
entry by default. Okay, thank you, sir.
All right, good day to you, ma'am. Wish you well.
Thank you. You too. Thank you.
All right, the court now calls case number 22-185-305. This is Fox Point Townhomes versus Jacqueline Lindsay. The matter is before the court set on for a pretrial conference in this matter. Your appearance for Fox Point, please.
Good morning, Your Honor. Attorney Ashley Nonis on behalf of plaintiff.
Thank you, Ms. Nonis, and good morning to you. For Jacqueline Lindsay, your appearance at this time, please.
Good morning, Grant Munson for the defendant.
All right, thank you, Mr. Munson. Your P number on the record, if you will, sir.
It's P71994.
All right, thank you, sir. And I know, of course, the court did schedule this matter, allow some time for discovery under the scheduling order, and also set up today's date as the completion of discovery and a pretrial conference date. Someone go ahead and update me. Tell me where you are at this time.
Well, Your Honor, counsel and I have discussed this matter and settlement is near. We probably could use a little more time for discovery. I'm waiting on some responses still, but we may settle it before then. So if we can get maybe another adjournment for Grant 30 days, I think would be good. Wouldn't you think?
Yeah, I agree.
I think we'd be able to wrap this up.
All right. So I'll note for the record, of course, that some progress has been made. The parties moving along well with regard to discovery in this matter. A little more time may help with resolution and would definitely help with completing any issues of discovery. Accordingly, I will adjourn the pretrial conference date, adjourning over with that the discovery order. So I'm going to go ahead and set this matter. I'm going to set it on the 10th of January, 1/10/23. And that's going to be set at 10 o'clock a.m. 1/10/23, 10 o'clock.
Great. Thank you, Your Honor.
All the best to the two of you.
All right, thank you.
Thank you. Have a good day.
The court now calls case number 22-190992. This is Michigan Institute of Musculoskeletal Medicine LLC versus City of Detroit. Today's the date time set for a status of scheduling conference. Your appearance for Michigan Institute.
Good morning, Your Honor. Mark Gozier, P number 79070 for the plaintiff.
Thank you, Mr. Gozier. Good morning to you. For the City of Detroit, your appearance, please.
Good morning, Your Honor. Alfred Ashew, PA2536 on behalf of defendant.
All right, thank you, Mr. Ashew, and again, good morning to you, sir. All right, you're just at the, looks like the starting line here. Anything particular or special that either one of you want to bring to my attention at this time?
No, Your Honor.
Just need I think we still need a scheduling order. I don't know if I've received one yet.
Yeah. That's what I was
Just
thinking. I think that, yeah, we're at the beginning here, so I'm going to go ahead and set it up, give it a scheduling order, and so I will set the next action date in this matter. That same date will grant you discovery through that date. So the next action date in this matter is going to be the 8th of February, 2023. 2/8/23. And that's going to be at 9:30 a.m. 2/8/23 at 9:30 a.m. And discovery will be open through that period of time. And also provision number 6 will allow the parties to file motions under a limited order. That is, if you give the other side 10 days notice of your motion, I will hear it on the 8th of February. That does not preclude you from filing motions beyond the 8th of February. But if you've got something that comes up, you want to have it heard on the 8th of February, the pretrial conference date, I will hear it if you file your motion and allow the other party at least 10 days to respond. So you'll get the scheduling order in the mail from me in the next couple of days, and I'll see you at 9:30 on 2/8/23. All the best to both of you.
Thank you, Your Honor.
All right.
All right, the court calls case number 22196025. This is Tansy Smith versus First Third LLC. The matter is before the court set on for a status and scheduling conference. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Diane Jaber, P85451, appearing on behalf of Tansy Smith.
All right, thank you. Thank you, Ms. Jaber, and good morning to you. I think you said Jaber, correct?
Jaber, correct.
All right, thank you. Good morning to you. For the defendant First Third Bank, First Third LLC, I should say, your appearance at this time.
Good morning, Your Honor. Anthony Gonzalez, P85154, on behalf of defendant First Third LLC.
All right, thank you, Counselor, and good morning to you as well. All right, it looks like you're just getting started here. My inclination, of course, is to set up a scheduling order, typically starting out with a 60-day period for discovery and allowing certain other provisions. Anything you need to bring to the court's attention at this time? Any inquiries at this time?
No, not on behalf of the plaintiff, Your Honor. I think we are hopeful of a good faith resolution. So
All right, thank you.
the scheduling order is appreciated.
All right, so I'll go ahead and do that. Mr. Gonzalez, you're on the same page there, basically, sir.
Oh, that's correct, Your Honor. No objection to a scheduling order. I think this case is early enough that the parties can engage in meaningful settlement discussions.
Got it. All right, so I'll go ahead. I'm going to go ahead then with this, and I'll set it over for the 8th of February. That's going to be the next action date in this matter, and that's going to be at 9:45 a.m. That's going to be 2/8/23 at 9:45 a.m. And you'll get the written scheduling order in the mail. Discovery will be open through that date, 2/8/23. And paragraph number 6 does give you special provisions to file motions dispositive and otherwise if you wish to do so, and actually set the hearing on the 8th, with the only requirement that you give the other party at least 10 days notice prior to the birthday. Again, that doesn't include in the future, if this case keeps going, filing other kinds of motions if you wish. But it just, if something comes up that you wish to kind of get right at it, do so. You'll get that order from me in the mail in the next few days. I wish that you'll be well and the best of the holiday season.
Thank you, Your Honor.
Bye-bye.